Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Hello, it's another court case we're reviewing today. This actually came out a few months ago during some warmer months, but it's just a matter of limited time getting to all these. So this one was in the Fourth Circuit. It's called Hale versus O'Malley. As you know, O'Malley was the prior commissioner who recently resigned. In any event, okay, so the claimant was Hale. Hale was denied at ALJ and appeals council, obviously, because then she took it to federal district court and it went up to the Fourth Circuit. And here's what it is about. It's pretty good. So this claimant suffered from chronic back and hip pain. She'd already had Harrington rod surgery for scoliosis, and she applied for Social Security benefits in 2019. And by the way, I'm getting all this information from Adriana De La Torre. So I appreciate once again her very sound summaries. They really help us a lot. Anyway, claimant Hale, her primary complaint centered around the limited mobility she had due to those impairments and persistent pain. The ALJ determined that she retained the RFC. Remember that's residual functional capacity for light work. Light is not as low as sedentary, guys, and not as exertional as medium or heavy. To put it in perspective, light work generally means being able to be on your feet up to 6 hours of an 8-hour day and lift up to 20 pounds occasionally. Sedentary, on the other hand, would be sitting for 6 to 8 hours a day, so therefore 2 or less hours on your feet and lifting no more than 10 pounds. Okay, so light work is quite a bit more. It's not necessarily heavy lifting, but it's heavier than sedentary, and it's a lot of time on your feet as a general rule. So when the ALJ determined that she could do light work, which means he found her so limited she couldn't do medium or heavy work, okay, granted, but he did not fully explain how she could perform those duties, the light duties, on a full-time basis, despite her impairments. The ALJ applied the 5-step disability framework, and I believe we do have a playlist on that, the sequential evaluation process, if you want to look at it. It goes over the 5 steps. And this ALJ concluded that although claimant Hale suffered from severe impairments, they did not meet or equal listed impairments under the Social Security guidelines. And that's not unusual, guys. I think we've been through this before. Listing, they determine first if you meet a listing under step 3. And that is almost an exacting matchup between what the listing says number-wise and kind of objective versus what your medical records say. So it's kind of hard to meet. Some people do. There's also an ability to equal a listing if you don't meet it. But again, that's the rarer, I would say, for most garden variety, say back problems and hip problems. So she didn't meet a listing. So then, of course, the next step after you don't meet a listing is to determine your RFC, residual functional capacity. And the key issue here arose in that RFC determination because despite finding that her pain and symptoms were intermittent, which I guess she had said, they were worse at times, not at others, the ALJ failed to explain how she could stand or walk for 6 hours a day, which is that light criteria, right, as required for light work. This lack of clarity undermined the decision. So it sounds like the judge put her at light, but didn't maybe discuss those intermittent bouts of exacerbations of that pain and limited mobility that might take place during that 8-hour day when she's supposed to be doing that light work. I didn't read the decision. I'm going on Adriana's summary here. So the Fourth Circuit found that the ALJ skipped certain essential steps in connecting the evidence to the conclusion. She gives a few instances here. In the medical opinions, the ALJ reviewed the opinions from Hale's treating physicians, and they supported her claim of disability. And then the ALJ also reviewed the independent consultants who did not support disability, meaning they found more capacity than would warrant someone being disabled fully. Instead of relying on these opinions, though, the ALJ based her decision on her own reading of the medical records without sufficiently addressing discrepancies. It sounds like she didn't take as fact the conclusions of either the treating providers or the independent consultants. That's what it sounds like from this. And she devised her own RFC based on her own read of the medical records, but she didn't really sufficiently address why hers maybe differed from the medical experts, which would be the treating doctors and the independent consultants. Under the pain analysis, while the judge acknowledged that claimant Hale had baseline of pain with intermittent fluctuation, the ALJ did not explain how this pain could be managed throughout the full workday, particularly with the demands of light work. So that's really good, guys, because pain, we know it's such a difficult thing to prove precisely, right? It's subjective, even though we know it exists, and diagnostics don't always tell the story as much as we need it to. But I like this, that it's recognized that if someone has intermittent pain, worse, better, fluctuating throughout a day, then how could they be expected perhaps to do light work, on your feet while you're in this fluctuating pain and fulfilling your duties while you're on your feet? How could you do that when the pain is aggravated? In other words, how also could you then manage it so it doesn't interfere with your duties for that time period? Because remember, there's also off task. Like if you're going to be intermittently in pain and off task from your work, what if you're going to be off task for 2 hours out of an 8-hour day? Now you're no longer working an 8-hour day, potentially. So there's a lot of ways we can go with this, right? But I think it's good. And this must have been a remand. Okay, so she did not explain how this pain could be managed throughout a full workday, particularly with the demands of light work. And again, that is certainly on your feet most of the day and being able to lift 20 pounds occasionally. The Fourth Circuit did, of course, vacate the denial of benefits and emphasize that a proper RFC, residual functional capacity, determination requires an accurate and logical bridge between evidence and conclusions. The ALJ failed to address how claimant Hale could sustain that light work for 8 hours a day, 5 days a week, given her chronic pain. The court ordered a remand for further proceedings to clarify Hale's ability to work full time. Adriana kind of brings us a little summary here that says she sees that the case emphasizes the need for a clear link between evidence and conclusions in RFC determinations. And that's really important too, because sometimes we feel like we see a stamp, a conclusion, a result, and we don't see how they got there. And that's really not fair and it's not proper under the rules, which this case is now emphasizing that it's not. Attorneys must ensure that ALJs thoroughly explain how a claimant's limitations affect their ability to perform specific work tasks. The decision reflects the court's focus on the sufficiency of RFC explanations on disability rulings, urging lawyers to advocate for detailed evidence-based analysis that can endure appellate scrutiny. Oh, sounds like Daniel Jones was the attorney of record that secured this remand. So congratulations to Attorney Jones. So that's a good one, guys. The direct explanation of how they get to the RFC from those medical records. Okay, I love it. Hale versus Commissioner. Talk to you guys later. Bye.